Welcome to Law Sessions. I am Jennifer Housen. In this law session, we will look at the role and the operation of the courts in England and Wales. Now, there's a separate law session, of course, which deals specifically with the judiciary and the magistracy. Now, please bear in mind that whether your syllabus calls it English legal system or whether it calls it common law reasoning and institutions, the whole idea of this area of law is, of course, to let you understand the framework within which you're doing your law degree. So, for example, you need to know what is the background, how is the common law developed, what is statutory interpretation, what is judicial precedent, how do you look at legal research, what is legal aid about. All of these provide the basis for you to understand what it is you're doing. We will explore the criminal justice system, we'll explore the civil justice system. All of these, of course, allows you to understand the context of your studies as it relates to law. Now here, we're looking at the courts. We're going to look at structure. We're going to look at what they do. We're going to look at what is it that their purpose is within the context of the common law system and in fact in the legal system in general. From this area, if for example you were to focus on a particular question within an exam, the kinds of things that you have to consider are, for example, how the court structure works. But this kind of question does not necessarily stand on its own. You may have to consider the role of the courts insofar as precedent is involved. Equally, the role of the court within a modern legal system so far as it involves how the courts interpret statute. But most importantly, you may have to consider, by way of a specific question, the whole issue of the Supreme Court within England and Wales. Now, that is something we will touch on later on in this law session, and I will focus to a degree on the idea, the role specifically of the Supreme Court. All right, let's make a start. When we look at the role of the courts in this modern legal system, what is it that we're looking at? Well, the idea of the common law arose from the basis of judges of the English royal courts deciding cases, and then the subsequent recording of those decisions which have been made. Now, with the dualities of the law is seen as an instrument of the kind of coercive power of the state and as the protection from the arbitrary use of power by others, whether it be the state or some other individual. So when you look at the law, the idea is the law is there, one, to protect you, and of course for you to follow it within the confines of what is set out. So more or less everybody is free, but you're free within a legal framework, because you're not just free to do something which is unlawful. Now, when we look at the idea of the state and the use of power and so on, the courts provide the forum where the power becomes manifest. So in the decisions made by the courts, then when you look at, let's say, the state being violent against you, the court may decree that it is legitimate. So, for example, when you look at the context of the European Convention on Human Rights, you have a right to life, but it is not an absolute right, for example, because that right may more or less be suspended when you're looking at war. So when you look at the violence of the state against an individual, it may be decreed as legitimately used against an individual. Equally, an individual may be protected against the use of state power. Now, this, of course, is in line with the rule of law as developed by, or not so much developed, as expounded by A.V. Dicey. And when you look at the rule of law, it has three elements. Now, certainly if you're doing public law, there is a complete separate law session on the rule of law, but for those of you who are focusing on just English legal system or common law reasoning in your first year, you just need to know this in a somewhat abbreviated format. The rule of law is the idea that everybody is subject to the law. So when we're looking at the courts, the court, of course, forms part of the framework of the law. And the idea of the rule of law is that it is encapsulated in 3 points as expounded by A.V. Dicey. And he says that there should be no sanction without breach. And what that means is that you should not be punished by the state unless you have broken the law. So, for example, you will happen upon a case called R&R. And in that case, it was about whether or not someone could be charged for rape in the context of a marriage. And albeit that the law prior did not say that, or rather provided that if you're married, arguably you have consented as a woman to any kind of sexual intercourse. The case of R&R said that rape could occur in such a relationship. The point, of course, was that when you look at the law before that, that was not how it was. But the rule of law provides that you should not be punished by the state unless you've broken the law. And this is an extension of Article 7 of the European Convention on Human Rights, which looks at, again, there should be no retrospective criminal punishment, for example. So, again, if the law wasn't in a particular state at the point when you did an action, you should not be liable. The second point of the rule of law of the 3-part is that one law should govern everyone, including both the ordinary citizen and state officials. So basically, nobody is above the law. Everybody is equal under the law. Now, don't forget that some actors, some state actors, like the police, may have a little bit more power than you, in that they may, of course, be able to deprive you of your liberty in circumstances where you're arrested. But by and large, what this second point means is, for example, there was a time in France where, when you look at matters relating to state actors, there was a separate administrative court for them, and they did not go into the regular courts where the ordinary citizens do. Well, that's not the case in England. Everybody gets tried in the same court. So nobody is above the law in that respect. Thirdly, the rights of the individuals are best secured by the decisions of the judges in the ordinary law, as opposed to being written down. Now, this third part of the exposition of Dicey in relation to the rule of law has somewhat lost its significance, not least because we see a sort of prolific rise in respect of written we see a rise in respect of statutes. So by virtue of the statutes, we see that this third requirement, that the courts are the best guardians in relation to citizens' rights, does not really carry sway anymore. Now, the real importance of the rule of law today lies in the basic idea underlying all 3 of his points. Now, as I said, when you particularly look at the first point, the idea is that the state should use its power according to agreed rules, and it should not, of course, arbitrarily use its power. When you look at the constitutional law book, Wade, a constitutional administrative lawyer, 1997 document, we see that it defines this in terms of an injunction that government should be conducted within a framework of recognized rules and principles which restrict discretionary powers. It is the courts, he argues, whom restrict these discretionary powers. We see that courts and the role of the courts is indeed very important, precisely because when you look at the powers wielded, for example, by the executive, now we know that by virtue of the framework of the law, which is that when you look in any jurisdiction, you have the executive, the legislature, and the judiciary. when you look at the legislature within England and Wales, Parliament is supreme. So a court cannot strike down an act of Parliament. However, when you're looking at the executive, which are the policymakers, if the executive does something which is wrong, it is the function of the court, or one of the functions of the court, to be able to review the exercise of this power and then to make a determination whether or not that power or use of it has been lawful. So, when you look at what Wade says, he says the courts have a central function, and that as it relates to disputes as to the legality of acts which are to be decided by judges who are wholly independent of the executive, they have the right to carry a dispute with the government before the ordinary courts, manned by judges of the highest independence. It is a common element in the Anglo-American concept of the rule of law. So as I say, if you have some kind of beef, some kind of problem with, say, the Crown or the ministers of the Crown, the cabinet ministers, you would take it to the ordinary court because the judges remain independent. Now then, what do we need to concern ourselves with when we look, for example, at the decision making by the courts and its place in the social structure? Well, courts are formal structures for decision making. Now then, there are various things that you have to consider when you look at the structure of the courts. The first is the legal reasoning which goes on there. The court's particular methodologies used for justifying and disciplining their discretion is legal reasoning. It is different from the methods and logic of scientific explanation, and it is also different from moral, political, and economic discourse. When we look at what the anthropologist Gulliver and what he has to say about it, he says there are two types of ways that you settle a dispute. You can negotiate or you can adjudicate. Now consider negotiation. He says this occurs when each person, each party, is assisted by socially relevant supporters, representatives, and spokesmen, and each party seeks to exert what strength it can against the other, such strength ranging from forensic argument and skill to the threat of physical force, from moral pressures to offers or denials of other advantages. And he says here, the result that you're looking for, the settlement, is in effect some mutually acceptable, reasonably tolerable resolution of what is under dispute. And he says when you look at what has gone on in a negotiation, it is based on an assessment and demonstration of the strengths of the parties. Now this, he said, should be distinguished from negotiations which are conducted between the two parties alone and those mediated by a third party, because you can have a negotiation where A and B together are negotiating, but that's an individual thing, as opposed to where you have a third party as a mediator, either who's an independent person or a friend who may not have the power to influence the final settlement. He just acts as an individual there to, of course, mediate. When you look at adjudication, this is where a binding decision is given by a third party who has a degree of authority. Now, according to Gulliver, he says such a decision is in some way coercive in that the adjudicator, which is the judge or somebody similar to a judge, has not only the right and the obligation to reach and enunciate a decision, but that person also has the power to enforce it. Now, the ability to enforce may range from the absolutely little more than an effective public expression of some kind of accepted norm and standards to, of course, ensuring that somebody may very well be put in prison. So there may be actual particular expectations which apply to particular dispute. Now that of course means there are differences between negotiations and adjudications. I'm going to take a short break there, and as soon as we return, we look at the differences, and we will also press on to then look further at the wider role and structure of the courts in England and Wales.